15th for our attempt to try to settle amongst us.
Anything else from defendants?
My client concurs, Your Honor.
Yeah, Your Honor, I concur with everything Ms. Sawyer said. I think you picked an appropriate date.
Right, and the court will affirm that date of January 15th, 2027 with a one disclaimer, which is if the parties go the ADR route, they're to submit that request for ADR or the I guess the notice that private mediation isn't going to happen, and which would trigger and which would trigger the setting of ADR, and if and the court has some control over when ADR sets their mediations, but if it happens after January 15th to no fault of the parties, then the court's not going to find the parties in violation of that January 15th deadline. But the court does find that to be an aspirational deadline for the parties to have completed ADR. And if the parties go the private mediation route, then that would be a good deadline for the parties to complete private mediation.
Understood. One issue I'd like to raise about that, Judge, is the application of Rule 16I, which would actually require a joint certification that there is no pending discovery that needs to be completed, and also no motions that need to be ruled on for the purpose of settlement and for the purpose of parties being able to engage in settlement discussions. And just as a practical matter, one of the reasons why I suggested the date that I did is I do anticipate, that for us, at least on the plaintiff side, we're realistically likely to need to get through expert depositions to be ready to settle, at least if the defendants want us to be able to, make any discount on the full measure of damages. I'd hate to give that certification and then show up to ADR and say, gee whiz, with the amount of discovery still outstanding and the fact that we haven't deposed their experts yet, we're just not ready to make that concession. And just for the purpose of being able to avoid giving an incorrect certification, I'd like to raise that issue now so that I'm not required to essentially certify something that I don't believe is true.
And fair enough. I guess in a case such as this, I guess the court is accustomed to parties going to private mediation, but that may be an issue. If the parties are unable to certify that there's no disclosure or discovery issues, then ADR may need to, and the parties can't agree to private mediation, then I guess ADR may need to abide the completion of discovery. If the parties have been able to agree to a private mediator, then that obviously wouldn't be an issue. So I guess let's keep the September 30th, 2026 notice to see if the parties can agree to private mediation. If the parties are unable to agree to private mediation, then the court will issue. Then the court will need an update regarding discovery and disclosure in this case, and whether the parties are able to whether the parties are able to certify the required certifications for ADR.
Your Honor, this is Mike Obert.
Yeah,
I'm a bit confused. I'm reading 16I right now, and it doesn't say anything about a certification. There's nothing in here. I mean, it just says the court on its own motion or after consultation with the parties may direct the parties to submit the dispute that is subject matter of the action to an alternative dispute resolution program created and authorized by the appropriate local courts.
but
And it's commonplace to have early mediation on cases to try to save the costs under Rule 1. So I understand the court's position, but I would like to keep the date for the ADR, no matter what it is, whether it's private mediation or ADR. I'd like to keep it for the January 15th.
And the court recognize. I mean, again, typically in a case such as this, it would be a private mediation, so it wouldn't be an issue. If there's ADR certification that's required, I don't want to I don't want anybody to be required to certify something that they are uncomfortable certifying. So I guess I need to look at the rule, but my recollection is that there does require to be some certification regarding discovery and pending issues. So that's why it gives me some pause on requiring it. It sounds like the parties may be able to work out private mediation in this matter.
I mean, I'm certainly willing to discuss it, but just one concern I would have about a private mediation, and especially a private mediation too early, is, I don't want to throw anybody in particular under the bus here, but I've been to settlement conferences with some of these folks and they haven't made a single offer. And I wouldn't want to pay money for private mediation to go there and not even get a single offer for a single dollar.
All right. So let's take this in steps then. September 30th, the parties need to let the court know whether they've figured out whether they're going to do private mediation or not. If they're not going to, then they can include in their joint notice when they'll be able to certify for ADR. If the parties are able to agree to private mediation, then the court will keep that January 15th, 2027 deadline. If the parties are unable to agree to private mediation and require the court's system of resolution, then the parties can provide their positions as to whether or not they can certify as of September 30th sufficient for the court to be able to refer the matter to ADR, so in a fashion so that the ADR folks will accept the case and work with the parties. I think we're at dispositive motions. Does April 30th still work for folks?
That works for the plaintiffs. Thank you, Judge.
That's fine, Your Honor.
All right.
Objection, Your Honor.
Yes. Thank you. Does July 9th work for a trial setting?
July 9th works just great for us, Judge.
Concur.
Yes, thank you, Judge.
All right.
Yes, Your Honor, it works.
Now, as far as memorializing this, the parties are going to need to provide a consistent with the court's orders here. So if there's any questions as to what the court's orders were here, let's talk about it now. A joint proposed scheduling order for the court to sign off on. So any questions so that the parties aren't in disagreement regarding the dates that the court has ordered here?
I think or at least for the plaintiff, we believe we understood you, Judge.
Defendants, and this is really the time to talk about it, because I don't know that there should be a second hearing clarifying what was said today. So I want to make sure I'm clear. Go ahead, Ms. Sayre.
Judge, will you be issuing a minute entry with the dates that you have set for us already, and then we will issue a proposed scheduling order for the remaining dates? Is that what you're asking of us? We
covered a lot of ground. I don't want to promise that the minute entry is going to contain every single thing that we've discussed. So if there's any questions as to anything that we've discussed, I think now is the time to talk about it.
Your Honor, there's one issue, but it's not related to the proposed scheduling order.
Your Honor, I think my notes are okay. I mean, as accurate as I can be. I think I understand what you've said, and I'm willing to, put that out into something that we share.
Okay. Ms. Sawyer.
I think we'll be all right. I think if we have any disputes, if we want to save the court time, we will order the recording of the hearing.
Okay.
Ms. Sawyer is fine with this as well. Thank you.
The court will endeavor to try to get the dates into the minute entry, but I don't want, if one is overlooked, I don't want that to cause a delay in the matter.
Thank you, Judge.
Mr. Roberts, I think you had something separate.
Yeah, Your Honor. There's also an issue of the timing of the plaintiff's depositions. We were trying to depose them sooner than later, and so far that what we've been able to determine is plaintiffs are offering November for these depositions. So we're trying to figure out, as I mentioned before, we're having trouble agreeing on what time of day it is. So how does the court want us to address this dispute in terms of in-person and timing of the depositions? It's going to have to be sooner or later. We're going to do a full briefing.
So what are I understand in-person versus video. I don't quite, I think, have a handle on the reasons for why video is being requested. But that would typically be something that could be presented in a 2060 fashion, page and a half each, and the court typically wouldn't, in the past, hasn't typically even had to have a hearing on that, although sometimes if there's something unclear, it will. As far as the dates, how far apart are the parties on dates?
Well, Your Honor, this is an issue we haven't met and conferred about.
If I could respond, Your Honor, at least a couple of months 2.5 months.
Well, that's actually not true, Your Honor. Mr. Bear requested dates that were in mid-October. I consulted with my clients and I learned that one of them is about to have surgery, and that surgery is going to require a week of inpatient hospitalization to recover, and it will also require that she be on some pretty strong painkillers for a period of time after that. And that was the reason why I offered Mr. Aubert November 2nd and 3rd for a video deposition. Was one, the plaintiffs live in Kansas and I don't want to put them through traveling interstate that soon after a surgery. And relatedly, I can't, I'm about 2 weeks off from what he asked for, and I needed those 2 weeks because I want to make sure my client is not still on mind-altering painkillers when she shows up for her deposition. I will also note this is an issue we haven't met and conferred about. I've invited the defendants to meet and confer with me about this. They haven't taken me up on that. I do feel like they should get on the phone with me before we ask for a judicial ruling.
All right,
Your Honor, there's two plaintiffs. We can depose the other plaintiff that's not having this procedure, but we can address the procedure. Plaintiffs have not provided the date of the procedure. They haven't provided any medical anything related to medical. So we're kind of flying in the blind here to make a rule. That's why we would respect if we could brief the court on this.
All right.
Well, I was going to say, Your Honor, Mr. Roberts' comments really do illustrate why we should get on the phone before we bring this to the court's attention. I'm happy to have a detailed discussion with him. I've offered it multiple times. I certainly hope that he'll now take me up on that.
Your Honor, I'd like to be heard a little bit on the meet and confer issue, if I could.
Sure, and I apologize to staff. We're well into the noon hour, but I know this case has a lot of moving parts.
Yeah. So there's an ongoing dispute right now between plaintiff and defendants as to when a meet and confer is appropriate. And I've had an experience already with Mr. Doncaster in a meet and confer. In this case, it's recorded, where we have a meet and confer that ends up being just sort of this bickering argument, and Mr. Doncaster offering us hypothetical situations of the case that doesn't currently exist. What happens if I dismiss so-and-so, or what happens if I do this? And so what I have requested, and I don't believe it's unreasonable, is that Mr. Doncaster set forth his positions in writing so we can address them. He has sent me this week, I bet, 15 separate emails asking for a meet and confer on alleged deficiencies in my disclosure statement. And I've asked him to specify what those are so I can address them. Perhaps they're easy that I can go back to my client and just get some supplemental disclosure statement without having to waste my client's time. He refuses to put this in writing to me. And he says, well, I don't want to write you another 20-page letter. I'm not asking for a 20-page letter, Your Honor. You have a 26D procedure that says basically the parties have to give a limited description of what the dispute is. That's all I'm asking. And so I'm fine with meeting and conferring whenever we want. I just want to have meet and confers so I understand what we're talking about when I go into the meet and confer. I don't want to be bombasted by Mr. Doncaster and have him making stuff up as we're going along and offering me more and more hypothetical situations in which I'm on a meet and confer that should last no more than a half hour, and I'm on a meet and confer for an hour. And that is an issue that is coming up again and again in this case, and I would like that to be addressed. At a minimum, just tell me what the issues are before we meet and confer. I've provided that same courtesy to Mr. Doncaster on issues that I've asked to meet and confer over. I don't see why it cannot be reciprocal.
Well, Your Honor, I'd like to respond to that. That's simply not true. The issues I've had with Mr. Aubert have included, I've emailed him some fairly basic descriptions of what I wanted to talk about, and he would still come back multiple times and say, I don't know what you want to talk about. You need to give me a greater level of written detail. And that persisted for over a month until I sent him a 20-page letter. And then after a 20-page letter, he finally broke down and said, okay, well, he actually sent me a written letter in response that said, here's my 5-page response. I now no longer think that a meet and confer is necessary, but if you want to, after you've sent me a 20-page letter, I'm finally willing to do that. And the same has actually happened with Mr. Roberts too. I sent him a written description of what I wanted to talk about. I even pointed out I wanted to talk about the application of ARS 1226-02, I had already filed a brief on that subject as to a different defendant. And I pointed out that he had a full-blown brief on it, and he was still claiming he didn't know what I wanted to talk about. I similarly raised the issue with him that I wanted to talk about the the denials of large sections of the complaint before I filed a motion, and he still said, like, I don't know what you're talking about, even when I had been fairly specific in the email. And so the issue is not whether we're going to specify what we're talking about, it's whether the defendants have a right to subjectively claim that I haven't given them the level of detail they demand and require multiple written submissions just to get on the phone. And I think that's pretty unreasonable. I think if we identify a topic, even in general terms, that ought to be enough that they can get on the phone. And if they have follow-up questions to my initial notice, they can ask those questions on the phone, and I'm happy to go over it with them. But I think the whole point of the meet and confer and Rule 26D process is to get these disputes resolved efficiently. And I think a big part of the efficiency is if we can just get on the phone on a relatively easy basis and talk about the issues without needing to have a written submission in whatever level of specificity the defendants demand, then that's going to help us get things resolved a lot faster.
Your Honor, may I respond to
Your
that
Honor, can I jump
quickly?
in on this?
Yes.
I've got to correct the record. Mr. Doncaster's talking about the two motions that the court has denied a long time ago. He would not provide anything in writing, or it's very, very minimal. So unfortunately, I was talked in by colleagues at this office to just talk to him to see what the issues were. We of course didn't read resolutions. I asked for 3 days so I can confirm with my client, and then we can get back. Instead, he filed the motions anyways. And also during that initial meeting, it was because of that meeting, now that we and others that we require video recording of any meet and confers with Mr. or any conversations with Mr. Doncaster. So that's that one issue. And then also meet and confers are I've never seen anything like this, Your Honor, in the practice of law so far. That's why unfortunately we have to bring it to you. I urge you to read the emails if you don't mind, to understand the difficulties that we're having with Mr. Doncaster, and to follow up on Mr. Obert's discussions about the disclosure deficiencies. As mentioned, that's Mr. Doncaster's mentioned that they've also alleged that against us. I asked him what's wrong with our disclosure, and he will not provide any. He just says it's deficient, and he said that multiple times. Meet and confer, meet and confer. We're not going to meet and confer with Mr. Doncaster until we know what the meet and confer is about. So just that's my client's position on this. It's a very difficult situation, and it's unfortunate. But if the court has time to review the emails, I think the court will have a better picture of things.
Yes, Your Honor, this is Mike Obert. I would agree with everything Mr. Roberts just said. The emails speak for themselves, and what Mr. Doncaster described to you, I'm happy to provide in writing what was exchanged before the meet and confers before, because what Mr. Doncaster just reported to you is just not true. You know, with respect to the answer, I asked Mr. Doncaster what he felt was deficient with my answer, and he repeated time and time and time again that it was my answer that was deficient. I want to meet and confer. And
that's not true.
That's no, it is. So the emails will speak for themselves, Sam. So it's fine. But I urge the court to refer to the emails, because I submitted the most recent emails with respect to the disclosure, and you can see I gave him over the last weekend to think about it, and he came back Monday morning, and his response was, quote, "The thing that is deficient is your disclosure." That's it. That is not appropriate. And again, I don't want to meet and confer with him on something, especially if it's something that can be easily fixed.
Well, Your Honor, there's nothing in the rules that requires any written submission before a meet and confer, and particularly not one that meets the defendant's subjective level of specifications. I'll note Mr. Oberg's comments about what I submitted to him are just patently false. You know, one example of that, Mr. Oberg claims that all I said was your answer is deficient. That's actually not true. I actually pointed him directly to the portions of his answer that were responsive to the standard of care allegations and said, that's what I want to talk to you about. So he
didn't tell me what was
a
wrong,
pretty
Your
good-
Honor. Again,
May I finish my sentence?
no, I'm sorry, because you make such misrepresentations, Sam.
Your Honor,
It
I
is.
apologize.
You
Is he
said,
allowed to
I
interrupt
think
me?
these paragraphs are wrong. That's all he
Hold on.
does. He doesn't tell me
Mr.
what the
Everett,
position is.
And I'll allow Mr. Doncaster to finish, and then I'll go back to you, Mr. Ober, and then we
Thank
are
you.
going to have to wrap things up.
Yeah, so with respect to that, I did tell him specifically, which portions of his answer I thought were deficient. I don't think we need to have 20 questions by email. I think once you identify something good enough that somebody can know what relevant document we're talking about, we ought to get on the phone, because it's a massive waste of time to have to go through multiple serial emails trying to answer things until you ultimately submit a 20-page letter, and then somebody says, oh, well, now that you've submitted a 20-page letter, we don't need to meet and confer anymore. I'll waive the requirement. Like, that's not what it's supposed to be.
Your Honor, I'd like to respond.
Go ahead.
So, Mr. Doncaster, when he talks about his specificity, it's basically something to the effect, and I'm not quoting, I'm happy to share the emails because the emails will speak for themselves. But what he'll say is, I think your response on the standard of care is wrong. That's it. I just want to know, why do you think it's wrong? Why do you think my disclosure is deficient? Sending me an email that says the thing that is deficient is your disclosure is not telling me what's wrong with it. It doesn't give me any opportunity to know what we're meeting and conferring about. This has happened time and time again. And if the court likes, I am happy to share the emails because I am not afraid of them.
So the idea, as the court understands it, of the meet and confer is for the parties to have a pretty good understanding of the other's position before they have that meet and confer conversation, just to determine whether the parties can reach any resolution on that issue short of filing something with the court. So I don't want to provide too specific of guidance or to micromanage the parties' communications with one another, but I would ask the parties to communicate clearly with each other ahead of the meet and confer regarding the parameters and substance of their position, so that the parties can have a better informed and more productive meet and confer. Anything else before we adjourn? The court will issue a minute entry from this matter, and we'll try to capture what was discussed here, and we'll provide how much time do the parties need for to provide a proposed amended scheduling order for the court to review and sign off on.
Given that we'll probably be waiting for the minute entry, I would suggest 2 weeks, Judge.
Counsel for defendants.
That's fine, Judge.
Yeah, it's fine.
It's fine, Judge.
All right, so the court will look out for that by Friday, September the 4th. We'll sign off on that. And I appreciate everybody's time and everybody's efforts. Thank you to staff for sticking with us. And unless there's anything else, I appreciate your time and efforts. And this matter is adjourned.
Thank you, Judge.